Hi, this is Curt Verone, and this is Bill Maccarone. Brad is away, and we are here for another edition of Fire Law Roundup for July 3rd of 2023. And Bill, I got to deal with one issue here that if I don't mute this right when I have the opportunity, we end up with feedback and it gets ugly. So let's get right to this week's stories. First one is an interesting one. Get it over here in front of me. Out of Washington State, where a firefighter who, according to the complaint, and because it's a psychological condition, I want to stick to the facts and not speculate here. But the firefighter alleges that he's got PTSD, and as an accommodation for his PTSD, he has brought his dog, a service dog, to the fire station, and it's the Bill. You want to take a shot at pronouncing that? The Chehalis, I guess. I was doing the same thing. Us East Coasters will apologize for butchering that term there, but he's a firefighter with the Chehalis Fire Department, and brought his dog, which in my experience that happens. Folks bring their dogs, and some for service dogs, some just because they don't want to leave the dog home for 24 hours and they don't have a place to put them. So they don't have anybody to let them out. So whatever the cause, brings the dog, creates a little bit of a problem. Apparently he's told not to, but does it again. And he's reprimanded, and then he's told, don't do it again. And there was at the time, no consideration for his PTSD. I think there's some factual questions there, in terms of the notice. Was the department on notice? Did the firefighter jump through the proper hoops to request an accommodation? But the bottom line is he was disciplined and prohibited from bringing a dog. Then he asked for a reasonable accommodation, I guess, which was declined, and filed suit under both the Americans with Disabilities Act and the Washington State Law Against Discrimination. You'll see an acronym in there, WLAD, which is the Washington Law Against Discrimination. So the city, and I guess this case was filed in 2022. Early 2022, so they're in discovery. And one of the things that the city wanted to do was order both the firefighter to be evaluated. Now, they had sent him, when he first asked for the accommodation, they had sent him, and he had his own doctor, which confirmed that both, yes, he has PTSD, and yes, the dog is necessary for his support. It's a supportive service animal, so he should be allowed to have it with him. So he hit both of those with his own doctor. Then the city sent him, and the city's doctor agreed. Essentially, there was some minor differences, but essentially the second doctor agreed. So now the kid files suit, and the city is now asking the firefighter to go for a second city ordered evaluation, which he objected to. And then they want to put the dog through some sort of a service animal evaluation to determine if it is indeed a trained service animal.
I think we're so used to that, the doctors, the dueling doctors' opinions, you're used to that, where, my doctor says X, and then maybe the city doctor says Y, and independent doctor says Z, like all these different factors.
Yeah.
Here,
it's almost like lawyers. Like you
Yes.
get three lawyers, you get three different opinions, right?
Yeah. So they're going to send the dog to the doctor too.
Yeah. So, but it raises a couple of interesting issues. So, but at any rate, the court rules that he has to submit to the to the psychological evaluation. And I think the primary reason was first damages for psychological injury. So his mental state is an issue in the case. Therefore, the city has a right to have that evaluated by their own experts. So that's pretty much cut and dried part of it. I think the more interesting part of it is whether or not the dog can be evaluated. Okay. Yeah. And I don't know what your thoughts are. The court basically said,
the court said that no, you can't bring the dog in for this neutral evaluation.
Right. And the reason why is something that we learned, like it's the primary thing we learn in evidence class, right? That in order for evidence to be relevant in a case, in order for evidence to be admissible, it must be relevant in a case. And the reason why they said the evaluation could not be done was that whether the dog was certified or not was irrelevant. The issue was, did the city deny his accommodation?
Yeah. And did they, engage in an interactive process and go through all those hoops that's required?
Right. So whether this particular animal was certified or not is not relevant to the case. The case is he asked for an accommodation. The accommodation was turned down. It wasn't turned down because the dog wasn't certified. Now, if that's an interesting, I think if he was turned down, if the city said, yes, you can have a service animal, but not that service animal, then it would have been relevant, because that was why they did. We don't think that that's a certified animal. That's just your pet. That's not a support animal or a service animal. There's actually there is a difference between a service animal and a support animal. It has to do with level of training and different things. But certainly a service animal has to have some training. So the city's saying, well, that's just his dog. It's not a service animal. And the court said that's irrelevant. You refused to consider that. So therefore, it's really not relevant if this dog is certified or not. The question is, you turned him down. Did you have a legitimate reason? And the only legitimate reason that a department would have for turning down something like that is it's an undue hardship.
Undue hardship. Yeah. Absolutely.
And which I think, the fire department can make out a case in some cases, depending. But I think it's you should be able to make that case up front. You don't wait until you get sued to kind of come up with an undue hardship.
Yeah.
You can say, look, we get people with allergies. We've got, if we allow dogs, we've got to allow cats. If we allow cats, we've got to allow chipmunks and peacocks and everything else. So point being that I think the city can make the case, but you make the case up front. You don't wait till you get sued and then say, oh yeah, here's the reason why.
Yeah. And I think also, and it's something that really kind of opened, something I hadn't really thought of until I read this. I think the city has a compelling reason to say, we need some sort of certification that this is not your pet. And I'm assuming that's, at some point they must be able to, in the process, say, I come in tomorrow, I go back to work later this week, I bring my dog in, say, oh yeah, this is my service dog. I think there's got to be some sort of a way to say, no, it's a service animal. Here's my letter from my doctor, and here's a letter from some association or some, like a train to say this animal's been trained. And
but that's downstream. That happens after you've already said, yes, you can have the accommodation. Now we're going to talk about the details of
how can we make this work.
Right. And I was talking to Brad over the weekend because he read the case and he immediately reached out to me. He says, oh, that's a great case. And Brad actually had one similar. But some of the other issues have to do with the fact that the firefighter can't bring the animal on runs.
No.
So now you've got an issue. You've got some logistical issues at the firehouse about where's the animal going to stay.
Absolutely.
If the animal's not in a crate or something else, they have to be on a leash, because we don't want the animal running free, because if the trucks go out and the animal's running loose and so on. So a lot of things to think about, logistical thing, legitimate, not trying to, pick sides in this case, but there's a lot of logistical things. And then, the issue of allergies and other things that folks may have in terms of trying to deal with that. So, but unilaterally saying we will not entertain this as a reasonable accommodation is a violation of the FLSA.
The ADA.
Yes, the ADA too.
Yes.
What am I saying? I just got off the phone with somebody talking about FLSA, and I'm looking at your shirt, and the ADA,
we
Americans
know what
with
you
Disabilities Act. Boy, I'll tell you, my brain sometimes scares me.
That was a very interesting case. It was an interesting read, and it was a good one. All right.
Well, how about last Friday? Thursday.
Yeah.
So
last Friday you hit 3. So, and obviously I think the looking at the 3, the biggest one as far as long-term ramifications is obviously the Supreme Court decision as far as, basically race-based decision-making in college admissions is no longer really allowed.
And that's kind of in a nutshell. Students for Fair Admission versus the president. And I believe it's the president of Harvard University, and also the University of North Carolina.
North Carolina, yeah.
Yeah, they were accused of having racial preferences embedded within their selection process. And the decision, if you take the time to read it, pretty much throughout various stages within the selection process, particularly at Harvard, the case really seemed to focus more on Harvard, that it was pretty clear that race was a major and important factor in that. And the Supreme Court looked at some of the case law, looked back historically, and said that race-based remedies were never intended to be permanent solutions to a discrimination, and that they've got to basically comport with strict scrutiny, which those of you who study constitutional law, you pretty much know when something falls under strict scrutiny, it's going to be struck down.
Yeah,
it's
absolutely. And such a small, I mean, narrowly tailored and all that sort of stuff that exactly just
telling government interest. And now I think what this leaves open, though, because there are things that pass strict scrutiny, and that is where you've had past instances of discrimination.
Yes.
Then a remedy can be race-based when it's coupled with past discrimination. So that would be an example, because people may ask, what would be an example of something that's going to pass strict scrutiny? If there was some sort of a finding of race discrimination in the past, you can remedy it, but that's not remedy it for 100 years or 200 years or 300 years. They discussed in there 20 to 25 years. But I'm not even sure you can pin it down to that long.
Yeah. And I wonder a lot of I was thinking, how does this really relate to the fire service, or how will it relate to the fire service? I think a lot of organizations are under consent decrees for hiring and certain, and I think that my gut tells me that those are probably, especially if the municipality, if the city kind of agreed to it with the whether it was the Department of Justice or whatever the parties are, my gut tells me if it is truly to remedy a established problem that's recent, it could hold up. I don't know. I'm curious on your opinion on that, as opposed to
so,
that's
my point. Yeah, as long as it's got to be coupled with some sort of either a finding or an admission that there's been past race discrimination, just like there was at those universities. Certainly, at some point in time, there was, but a lot of these things go back to the 70s. We've got fire department consent decrees going back to the 70s. And that's the earliest I've seen. And so now you're talking 1970. You're talking about 50 years. So, at some point, there needs to be some sort of return to normalcy in terms of the selection process. And then we should be monitoring that, because if let's say we end a consent decree, but all of a sudden now we do a school and it shows a racial imbalance, well, now we've got another problem. So now we've got to figure out and tease out whatever is causing that and move forward.
Change that going forward.
Interesting. I think it's going to take a while for the impact. I know, depending on what news station you get your news from, you're going to get this spun in one or two directions. But the reality is the rest of us are going to kind of live in the middle and try to figure out how do we live with this going forward. So it'll be interesting.
It was very narrow too. It really was very narrowly, this has to do with Harvard. This has to do with, UNC, North Carolina, like you said. So there's a lot more to come out of this, I think.
Yeah, no, for sure. Next case was a case out of FDNY. And I thought it was interesting. And a couple of people had sent it to me, the link to the potential lawsuit, but it's not a lawsuit. So we don't really know what the allegations are. Typically, if you're going to sue government, prior to filing the lawsuit, you have to file what's known as an administrative claim or a civil claim against the city. Usually you'll file it at City Hall. Someplace at City Hall will take the claims. And then the city has 60, 90, 180 days, whatever it may be, to look at it and then make a decision, either pay it, settle it, or say we're not paying it, in which case then it goes to litigation. So this is sort of the first step in that process. But 3 of the firefighters, I think I saw a couple of different news articles, 17 and 19 firefighters were injured in this fire on Staten Island last March. reportedly several units were out of service. Several of the close-in units were out of service for medical exams, which allowed the fire to get bigger and delayed the response of the first alarm assignment. Bottom line is, the allegation is that there's, I'm assuming, some level of negligence that's going to be alleged on the part of the city, and the injured firefighters are probably going to be filing a suit on that.
Yeah.
So, and then the last one was actually a lawsuit. It actually involves the fire department. So the first one was a lawsuit, didn't involve the fire department. The second one was not a lawsuit, but it did involve a fire department. And the last one was a lawsuit involving a fire department, but it's so mundane that I didn't really want to get into the details of it. And there's actually, I mean, if you're really into public records law, there's some nuances in there. I don't know, Bill, if you had a chance to read the entire decision, but
I did, but I didn't pick up on the nuance you're referring to.
What in God's name is a pay-to-play law?
If you're a pay-to-play law?
Yeah, the case discusses whether or not this was a pay-to-play law, and I'm like, all right, we're going to lose people's attention getting into that level of detail on a public records case. But the bottom line is, they had this particular regional fire department, North Hudson Regional Fire Department, was going out to bid for someone who was going to manage their medical, I guess it's their medical costs for their employees. And I know I'll give you an example. In Providence, the city is self-insured, but they pay Blue Cross to receive all the medical bills for the firefighters. And this is not workers' comp. This is, on your private health care. But basically, Blue Cross handles all of the bills. You go to the doctor, they get a bill, handles all that, and then they have an administrative surcharge. So if they pay out $100, they charge the city $115, and that's where they make their money for handling all of the billing for them. And so that the city doesn't pay a $20,000 per employee premium, they just pay whatever the actual costs are. So sounds like that's what this bid was for, to have someone come in. And so one of the parties put in a bid. Another party apparently thought about putting in a bid and didn't, but then they put in through the public records law to get copies of the bids and copies of some of the selection criteria and all of that. And the fire department, and I'm not sure it's a regional organization, so I'm not sure how they have that set up, if it's like a fire district or what have you. But they basically said, no, we're not giving it to you. We have an exception to the public records law that allows us not to disclose this. And they took advantage of that. And so the provider that put in for the freedom of the public records law, that put in for the public records, filed a lawsuit to get access to it. And the court, both the trial court and the appellate division here, said, no, you're not entitled to it. There is an exception that covers this, and the fire department does not have to produce that. So,
yes.
All right, don't worry about it. Let's go to the next case.
This is actually interesting, out of Massachusetts. And
Very
basically,
interesting.
It's a restraint. It's like a restraining order. It's a harassment prevention order that it was two EMTs working together. They don't identify the EMTs or where they work together, but they're two EMTs working for a fire department in Massachusetts, female EMT and a male EMT. The female EMT, who's identified in the documents as ET, was how she's referred to here. Her colleague, JU, the other firefighter, apparently took some photographs of her from her Facebook page, changed them, modified them, cropped photos in there showing what appeared to be this firefighter in a very lewd sexual type of, and at the term that they use here, the terms they use is the images involved extremely sexual conduct, or I'm assuming individual engaged in, these were not real photographs of her. They were taking pictures online and just manipulating them and cropping them to make it appear that way. And as a result, there were some allegations that he was going to get her in trouble, saying she was not really doing her job correctly, incompetence and things like that. However, she went to court and got basically a restraining order against this other firefighter, or EMT, I should say. Now, he appeals. It takes quite a while, a couple of years really, for it to make its way to the court. And the court struck it down on what I would call is kind of a technical type of a thing, because it said that really this doesn't meet this individual. I mean, this behavior is horrific. I mean, I think it's horrific. I look at it as where, in what world is this acceptable? But it did not meet what I would call kind of a high level of harassment that's required under this specific statute in Massachusetts.
And let's talk about that, because there's a lot of different types of restraining orders. There's domestic abuse restraining orders in Massachusetts, and it's mostly state law. In fact, it's all state law. But there are a variety of different types of restraining orders out there. For whatever reason, ET's attorney, I'm assuming she got an attorney, the attorney proceeded under Massachusetts harassment protection. Is that what's called harassment protection order?
Prevention, right? Harassment
prevention order. Okay, got a harassment prevention order. And like any type of restraining order, there's certain things that you have to meet. So very commonly, if you have two people who get in an altercation, one of them is going to be able to get a restraining order against the other one. Okay, if you have a domestic assault situation, they're going to be able to get a restraining order. This was not either of those. There was no issue of assault or threatened harm or anything. This was essentially a harassment prevention order. And the trial court issued the order and told the firefighter or the EMT JU to stay away and basically stop harassing, which I think it solves the problem temporarily. Restraining orders can have other consequences too, because if you're under a restraining order and, for example, you have a concealed carry permit or other types of things, it can influence your right to carry and a lot of other things. So I can see why someone may not want to have this out there if they feel that it's not valid and necessary. So at any rate, JU contests it, and the appellate court agreed with JU, basically saying that it wasn't right. What you did was wrong, but it doesn't meet the technical definition of being harassment. Yeah.
And I think there was really no, I guess even by ET's admitting in court, according to the documents, really, she was never in fear of JU. It was definitely harassing behavior. I don't think anybody would say that that's not, harassing behavior, but under this law, it's very specific that there's some specific boxes you need to check.
Yeah, I would hope the fire department stepped in at some point. I know some fire departments' rules, they're a little bit ambiguous when it comes to off-duty conduct. And so I'm not sure. We don't even know what department it was, but not sure. But I would hope that the department intervened in this to manage this, in terms of discipline and whatever tools it has available. But that was not discussed in the decision.
Yeah.
So, interesting. All right. Next one's New Jersey. I don't know if you.
Yeah, Paterson, lawsuit out of Paterson, where a captain aspiring to be a battalion chief. I think captain's pretty good job. I look at the captain's position as
you say that as a battalion chief.
I do, but no, this is a captain from and I'm trying to think, was it Stephen Crampton filed a lawsuit in state court, and it was filed initially in state court, then got moved to federal court because there was some allegations of federal violations of due process violations, as far as some of the, I guess, the policies and procedures, at least the allegations are the policies and procedures of the fire department were infringing on his constitutional rights. But I think one of the interesting things here was, I'll kind of quickly go through, captain on the job for I think 17 or 18 years, taking the test for promotion to battalion chief, passes the test, but is not doesn't get the promotion. But in the meantime, we had something called COVID come along. So we had during the COVID, they couldn't have their civil service exams for a period of time. So there were some promotions that were made that were provisional in nature. So I think at the end of the day, they had promoted some captains to battalion chief, absent the examination process or absent some of the usual procedures on a provisional basis. Finally, the state turns around, they're offering these promotional exams. Captain passes and is not more or less moved up immediately, and the provisional appointees were not moved down immediately. And that was kind of, I think that's the for me, that's what I picked up as far as kind of in a nutshell, his allegations. Obviously, there's some state law claims as well. Curt,
there's a backstory there where he's alleging that he made some he reported some misconduct and some improprieties. And also that he had a little bit of a feud with some ranking officers, and that is what sparked the decision to handle the promotions in the way. So essentially what you have is you have COVID in, because of COVID, the New Jersey civil service system, which I'm assuming is a lot like the Massachusetts system, which if you're going to be promoted, you got to take the civil service exam, and the state civil service kind of regulates promotions in municipal fire departments, which is really alien to us because, you know, we promote from within. We don't have to deal with any sort of state bureaucracy, but, you know, states like New Jersey and Massachusetts have this civil service bureaucracy that you got to jump through. But bottom line is the state, because of COVID, stopped the promotional process, so stopped the promotional exam. So there should have been an exam. There wasn't an exam. There was a couple of battalion chiefs openings, which were provisional, which I assume is somebody's off injured or sick long-term. The positions aren't permanently available, but you can put for battalion chiefs, you can put a captain in there provisionally. So comes time for the chief to put some people in those positions, and they don't put this particular Captain Crampton, in there. Which apparently is fine because, you know, it is what it is at that point. But then they do have the promotional exam, and the two captains who are in the provisional spots don't take the exam. Captain Crampton does take the exam. He passes, and I think he's eligible for promotion. He comes out, you know, up at the top. He's eligible for promotion. And according to civil service rules, if you have provisional spots and you have a list, you're supposed to put the person on the list in the provisional spots. Sure. And the fire department didn't do that. So he's suing under the state civil service regs to basically force the city to put him into those, put him into that position. Now, I would have thought that there would have been a way through civil service that he could have grieved that. He wouldn't necessarily have had to file suit to do that.
I'm sure we're going to see in the city's answer if we're going to find out when the city answers this complaint. Yeah. You know, I would assume, but yeah, there's got to be some sort of a remedial in between, you would think.
You know, and the reason I say that is, you know, filing a lawsuit, unless you have a relative that's an attorney, filing a lawsuit like this is pretty expensive. Yeah. And, you know, whereas filing a grievance at the civil service level is probably free. And it's something that maybe a union rep can handle, or, you know, maybe you need an attorney, but it's not nearly going to be as expensive as taking a case like this to court. So I don't know. We'll see how that plays out. But he is alleging that he's being retaliated against in violation of the New Jersey's Conscientious Employee Protection Act, which essentially is a whistleblower protection act. Violation of New Jersey's constitutional protections for free speech and assembly, and also retaliation of essentially a violation of his due process rights, as you suggested, which is how this got kicked up to the federal court.
Yeah.
So yeah, that Monell claim. So yeah, so that's it in a nutshell. Quick week. Brad is on his it's his anniversary vacation. So he and Nicole got married. I think it was, I don't know if it was 5 years ago, 6 years ago. So so he's away, and but he'll be back. And we got a class coming up this week. So
Thursday.
You know, he is accessible. He was just afraid where he is that he would not be able to have a good connection. And so we got Bill here pinch hitting. So.
Well, thank you for the opportunity.
Well, thank you. Thanks for joining us. And that's going to do it for another edition of Fire Law Roundup.